Hello, thank you for the opportunity to present today. My name is Bill Eubanks, and I am the owner and managing attorney of Eubanks & Associates, PLLC, which is a Washington, D.C. based public interest environmental law firm. In my 2 decades of practicing environmental law, one of the areas I've specialized in is federal wildlife law, including under the Bald and Golden Eagle Protection Act, or BGEPA. BGEPA is located in our U.S. Code at 16 U.S.C. 668. There, Congress created civil and criminal penalties for any individual, municipality, or other entity that, quote, takes bald or golden eagles. And take is defined quite broadly under federal law. I'm going to read the types of activities that are included. So an unlawful take includes pursuing, shooting, shooting at, poisoning, wounding, killing, capturing, trapping, collecting, molesting, or disturbing an eagle. And it's those last two types of sublethal take called molestation take and disturbance take that are most at issue here. And so what Congress did in federal law and how courts have construed that is that even when an individual or entity does not intend to molest or disturb an eagle, but it nonetheless results from an activity undertaken by that person or municipality or entity, that can subject the person or entity to civil and criminal liability because of the penalties built into the act. So importantly, there's no intent requirement. Even if you do something on accident or it's unintentional, it still is an unlawful take under this strict liability statute that can lead to civil and criminal penalties. And because of this, it's really important to look at the result or the outcome of an activity to determine whether it contravenes the Bald and Golden Eagle Protection Act. I've worked with front range nesting bald eagle studies for 7 or 8 years now, and I'm very familiar with their data collection methods and their rigorous methodologies, as well as the reports and studies that have resulted from their data collection. And in my review of their data and their reports and studies, it seems very likely that this situation with the cutoff trail being very close to the Stearns eagle nest has resulted in this type of molestation or disturbance take. I mean, this is kind of a textbook or classic example of an activity that is happening that is loud and is causing the types of disturbances that can adversely impact foraging behaviors, nesting success, reproductive success, and other types of essential biological functions that eagles have to be able to carry out to survive not only year after year, but from generation to generation. And so if you look at the statistically significant data, what the data appears to show pretty clearly is that when the cutoff trail opens in close proximity to the nest, the eagles are flushed from the nest, they're disturbed, they're molested in that sense, and it can have these adverse behavioral effects. And then once the cutoff trail is closed, they're coming back to the nest, which is a good sign, but it may not be a permanent thing. After a certain number of seasons of flushing and disturbance, we do often see that wildlife start to abandon a particular nest site or location. So in any event, I appreciate the opportunity to speak with you all today. To summarize, I do have concerns about this routine repeated behavioral disturbance that appears to rise to the level of take under the Bald and Golden Eagle Protection Act, but there are opportunities either to no longer conduct this activity to avoid take, or potentially to go to the federal regulators to see if lawful authorization could be given subject to terms and conditions to ensure compliance with federal law. Thank you so much.